products.
Yeah. All right, I think it's going. So welcome to the first Our Revolution McLennan County live stream. Our guest today is Rebecca Flavin. She's going to be speaking to us on a very important topic, which is gerrymandering. It has a whole lot to do with, a whole lot more to do than you think with how elections turn out. So without further ado, Ms. Rebecca Flavin.
All right. Well, thank you guys for inviting me and having me. I'll apologize to the people sitting at home. I'm like the least photogenic person and not very good on camera. So you can be here in person. I'm more charming in person, just marginally. But thank you guys. This is a lot of fun. So this is a topic I enjoy talking about, even though it's kind of depressing. So I assume if you're here, you're politically motivated, you know something about the topic. But if there's anything that I sort of pass over and assume that people know that, you want me to pause and ask questions, I'm happy to do that. Also, I don't claim to be an expert, so there are probably questions that you'll have that I can't answer. So if I can't answer them, then I'll go look it up and get back to y'all later. So gerrymandering, as you know, it's a problem. It allows elected officials to choose their voters rather than the other way around, which is really, it's the antithesis of what democracy should be. And it has ripple effects. So when you have a heavily gerrymandered district and you basically have elections that are determined in a primary, which is often the case, then this has attenuated effects for turnout as well, because who wants to come vote in an election that's largely already determined, and this cuts both ways with both parties gerrymandering. Just a couple of statistics from 2016 for Texas. 71% of state legislative offices were considered to be heavily gerrymandered with an electoral margin of greater than 45%, which is determined as a landslide win. 66% of the state legislature was determined before the general, meaning it was the primary that determined the race. And so that's indicative of gerrymandering. Of course, gerrymandering is named after Elbridge Gerry. I think it's fitting for Elbridge Gerry that we say his name wrong, so I'll keep calling it gerrymandering instead of being pretentious and calling it gerrymandering. But so he infamously, whenever he was the governor of Massachusetts, encouraged the state legislature to redraw district lines in the eastern, more rural part of Massachusetts to disenfranchise rural voters in particular. So along the border, you had this district which looked like a salamander. So someone cleverly called it a gerrymander. And so you get one of the most famous political cartoons in history, and the rest is history. In terms of what I want to talk about today, what I teach and study about related to this is the courts. And so I'm going to talk about one briefly sort of where we're at with respect to gerrymandering, and I'll just talk about that ever so briefly, talk more about the courts, where they've been and potentially where they could go, which is very depressing. And then I'll give a more hopeful ending with where we, the people, could go. So just, in terms of vocab, and here you guys probably know these terms, but just to make sure, reapportionment is the process of adjusting the seats after each census every 10 years to account for population shifts among the states in the House of Representatives. Hey, come on in. And then consequently, the assumption is that if a state's number of legislators changes, that the state is going to then redistrict to account for this. And so the assumption today is those districts are going to be roughly equal in shape, but that wasn't always the case. And in fact, I think it's shockingly recently that you get the principle of one person, one vote. So it starts with Baker versus Carr, a case in the early, hi, come on in. Baker versus Carr, a case in the early 1960s, 1962, in fact, because up until this point, all of the cases challenging state or federal electoral maps were brought to the courts under the guarantee clause in Article 4 of the Constitution, which says that states shall be guaranteed a Republican form of government. And so when the courts would get these cases, they would say, we're sorry, we're not qualified to rule on this. This is something called a political question that's best determined by the legislative body. So something we don't have the expertise or the constitutional authority to really pronounce on. And so finally in Baker versus Carr, people wisened up and realized, hey, there's a whole toolbox of other parts of the Constitution you could potentially look at, specifically the Equal Protection Clause. And so they challenged the map in, I think it was Tennessee that year, under the principle that it violated the Equal Protection Clause. So in Baker, the court says, okay, this is potentially justiciable. We can potentially rule on a case that's a violation of the Equal Protection Clause. It's not until 2 years later in Reynolds versus Sims that they actually do say, yes, a malapportioned district violates the Equal Protection Clause, and they establish this one person, one vote rule. Now, one person, one vote means that theoretically districts should be as equivalent as possible. So they have the ideal population is the number, and so the county judge, here the county commission, when they're drawing district lines for McLennan County, for instance, will have an ideal population for each of our 4 commissioner districts, for instance, but the Supreme Court has approved some variation. So the variation they're more strict about when it's a federal legislative district, and so they've approved up to about a 10% variation from the mean for a specific district. But at the state level, there was a Texas case in the 1970s where they approved up to a 19.5% variation between districts. And so the reason for this is that the variations helped achieve other goals, such as, well, in the Texas Constitution, there's the provision that states that counties should be kept together for the purposes of drawing district lines. So that was one consideration they made, was state autonomy. But 2, they look at, is it compact, is it contiguous? And when you have a behemoth of a state like Texas, that justified a wider variation for the state legislature than it would for the federal legislature. So just because a district isn't exactly or numerically even, it isn't necessarily a problem or unconstitutional. They do allow some variation. This is a really important issue for us right now. It's an important issue for this election. It's an important issue for the next election because after the census in 2020, the federal government has up to a year to send the results back to the states. And so it will be roughly April 2021, from what I understand, when the states will get the data saying, here's your population, here's where they live. Then those statistics need to be taken into account, and district lines need to be redrawn in time for the 2022 elections. That's a really short turnaround. And so that process happens really fast. And so that means that people who want to push back against gerrymandering have to get motivated, they have to get organized, and they have to prepare to do it pretty quickly, because the process happens over the space of, I think, about 6 months. And you also have it happening simultaneously at different levels. You have it happening at the state level, the county level, and in municipalities as well. The complicating fact about gerrymandering today is that technology makes it really, really easy to draw districts that look benign or innocuous, but are very much drawn with nefarious intent to exclude people on the basis of race or ethnicity, or to exclude or diminish their impact on the basis of political party. And so technology makes it a whole lot easier to exclude people than in the time of Elbridge Gerry, where they don't have data that can tell you block by block, this is how many Latinos who live here, how many African Americans live here, how many Republicans, how many independents, how many Democrats. And so the problem, the real difficulty is that, largely from the 1960s up until I'd say 10 or 15 years ago, one of the things that the court would routinely emphasize was an odd shape. And in fact, you get, lots of, interesting, fun cartoons looking at strangely shaped districts, like the district that encircles Chicago and the suburbs, and it looks like earmuffs to keep people together. You have one that goes down the center part of the state of Florida, which kind of looks like the map of Italy, where you have sort of a line and then a little boot. We of course have our own interesting district shapes here in Texas. Maybe we could put up an art display like name or a Rorschach test, like tell me what this district looks like, especially as they radiate out of Austin. Gallows humor for us. But so the court has previously looked at, is it a funny shape? And sort of that's been their sort of initial litmus test to determine this is a gerrymandered district. You can't do that anymore because software, you can't look at the shape alone. Let me rephrase that. Shape alone isn't going to tell us that it's gerrymandering, because increasingly sophisticated software, you can draw districts that basically look compact and contiguous, but which are heavily gerrymandered. And that's ultimately what was part of the issue in the Wisconsin case that the Supreme Court sent back. Gill versus Whitford. So I think the two ways that districts can be gerrymandered, you get packing and cracking. And so packing is putting voters of a similar political party or ideology together so that you create a district with a supermajority, so that the votes are essentially wasted. And so that's how you can get your voters packed into a district that looks compact and contiguous, and then districts around it, might have funny shapes. Another option is to crack or fracture districts, and that's where you break up a group and diminish their impact by spreading them across different districts. And that's basically what you see with Austin, the city of Austin, and their population is cracked into lots of different districts, including our own U.S. House district. District 17. So on to the court. So what's the court done with gerrymandering? So racial gerrymandering, there are several different cases throughout the 80s, 90s, and early 2000s. And a principal takeaway point from those cases is that race couldn't be the only determining factor for drawing district lines. And so whenever the Voting Rights Act was in play with the principle of preclearance, that districts with a history of racial discrimination would then have to have any electoral policy pre-cleared by the federal government. You would then get some districts that would be majority impact district or majority minority district, with the understanding that these would be a remedy to past discrimination. You no longer can get sort of, I would say, an affirmative look at a district that way, now that Section 4, the preclearance formula, was tossed out in the Shelby County case several years ago. But I want to focus specifically on partisan gerrymandering, because that's the issue that's getting the most play right now. And ultimately, a lot of partisan gerrymandering turns out to be racial gerrymandering as well. So the court, you see sort of a similar pattern here with redistricting, where in the 70s, they would just dismiss a case and say, we don't have standing here, we can't review this case, because there isn't what they called a judicially manageable standard for resolving it. Basically, it's out of their wheelhouse. And so that's a case called Gaffney versus Cummings in 1973. Fast forward 13 years to Davis versus Vandimer, another partisan gerrymandering case. And there, it's from Indiana, and there the court warmed up a bit and said, this doesn't pass the smell test. There's something wrong here. But they couldn't, again, agree on what the courts should do about it. So it was sort of like, we see a problem, but we can't come to a consensus on how to resolve it. So then nothing happens and the case just bounces back to the state. For the first time, the court, I think, gets closer to recognizing that partisan gerrymandering, similar to racial gerrymandering, could pose problems under the Equal Protection Clause, and a case called Wyeth versus Jubileer in 2004. And that was a Pennsylvania case. And so the court was all over the place. They have a plurality opinion that decides the case on pretty narrow grounds where they again say, this is a problem, but we don't have a way to solve it. But in a concurring opinion, Justice Kennedy, who just retired this summer, as he sometimes does, gives hints about, well, here are some of the things I might like to see in an opinion that would help me to determine what a manageable standard would be. And so Kennedy's concurring opinion in the Vythe case has sort of been what scholars and attorneys working on partisan gerrymandering cases have used as sort of their guide for the next generation of cases in the past 14 years for where to go with those. And so that brings to Gill versus Whitford, the Wisconsin case that the court made an initial determination on this year, but then tossed back. So what several scholars, his name, Nick Stephanopoulos and Ruth Greenwood, who are law professors at the University of Chicago and attorneys, along with a friend at the University of California, maybe at Berkeley, they devised something called the efficiency gap, which would be a specific mathematic measure that you could take to a court to show that districts are gerrymandered. And so what it would do is take all of the districts, what it does rather, is take all of the districts in a state, compare them to each other, and look at that gap, the efficiency gap. How many votes were needed to win this district? How many votes did the person who won have in excess of what they needed to win? And so what they're testing for in large part there is packing. Have people been packed into a district? And so you can look at this variation across districts and see, is this a competitive district where someone wins by a small margin? That's sort of like an ideal under this measure, something that's to be desired, a competitive district where you don't have wasted votes. Whereas on the other end of the spectrum, when you have a huge blowout, that would be an indicator of something being off. So they applied this efficiency gap standard to the Wisconsin state map and looked at it over a period of years leading up to this year to show that that legislature is Republican controlled, to show that they had basically over the course of 3 years had basically efficiently gerrymandered Democrats out of potentially a number of seats. So they take the case to the Supreme Court. And the court dismisses it because they said that Whitford and the other petitioners didn't have standing to sue. And so here's where it gets a little complicated and frustrating, because the efficiency gap presumes a statewide measure and a statewide basis. So to use the efficiency gap, you have to compare the districts all to each other. And so here they dismiss standing because Whitford and the others themselves didn't live in individual districts that they determined were gerrymandered. So what they indicated is that for someone to have standing, you need to have a personal stake or a personal injury. It's like law 101. Whitford lived in a district with a Democratic rep, one of the few. So they said, well, I mean, clearly he still gets to elect his Democrat, but part of it's missing the point, the efficiency gap if it's a packed district. So what they do is set with this case that you're going to have to challenge it district by district. Yeah. District by district. And so it makes it hard, I think, to use the efficiency gap because they're saying you can't really challenge it standing wise on a statewide basis, And Justice Roberts hints that the remedy wouldn't necessarily be statewide either. Instead of redrawing the entire state's district lines, you just redraw the ones that are affected. Similar to the racial gerrymandering Texas case this summer, District 90 around Austin, they're not going to redraw the whole state of Texas. And they're not redrawing anything before this election. They'll just tinker with the lines around it. So what next? They sent Wisconsin back down, and so Stephanopoulos and Grant are going to have to, I think, rethink their strategy. So their strategy was, I think they were basically aiming toward Kennedy, and Kennedy's retired now, so that strategy is no longer workable for one. But two, it's further complicated because even if they get past the initial hurdles for standing, the judicially manageable or workable solution is still a problem. And it's a problem because the court, what they're going to look at once you get to hearing a case on the merits is two things. Like, they're going to take a two-pronged approach. They're going to look for, one, an intent to gerrymander and an effect to gerrymander. And there's no universally agreed upon standard for judging what constitutes intent and what constitutes effect. So intent, some of the things they look at, as I mentioned before, is a bizarre shape. Well, that isn't indicative in and of itself of gerrymandering, especially when you have sophisticated tools where you can draw something that looks like a blob, but you just have different blobs. So the state of Wisconsin, in their approach in Gill versus Whitford, they wanted the court to establish that any normal-looking district shouldn't be challenged at all. And so that's a really troubling approach, that if the court adopts a normal-looking district can't be challenged, then this makes it difficult moving forward. Some said if you have proof that legislators looked at partisan data whenever they drew their maps, if they took into account trying to diminish voters, so if you have proof of this, that could serve as intent. And that's part of what happened in North Carolina, is that they were pretty brazen about it. Now, I don't know that all legislators will be that brazen or open about it, but I mean, they're just like, well, of course they're going to diminish the impact that the Democrats have. Then you have, from another racial gerrymandering case, Thornburg versus Gingles, the Gingles factors. I think the closest thing that there is to a test, and it sort of combines both intent and effect. And so what it's going to look at is, do you have a geographically compact minority population sufficient to constitute a majority in a single district? Is that group politically cohesive? And is there evidence that this group would vote in a block to defeat a candidate? So you've got some sort of like both intent they were excluded, but also the effect that these people would have if the line was drawn differently. Effect is also tricky, and this is the thing that honestly worries me most, because depending upon how they define effect, it could lead to prolonged legal battles that extend beyond a single map's life cycle well into the next census. So some justices have signaled that for effect, they want to see that there's a discriminatory effect that isn't linked to a single election cycle. So you're looking at multiple elections. So you're talking years. That's bonkers. And so some have said they want to see a trend that's likely to continue. So maybe not looking at multiple elections, but looking at sort of hypothetical trends. Other justices have said this is a kind of forecasting with a crystal ball that we just can't engage in. So it's tough. So the court would have to work out all of these things, and it's just not clear where they would go. There is another part of the Constitution, though, that could come into play. So here's where it gets hopeful. So all this is depressing, but now we're going to come back up. So Elena Kagan, in her concurring opinion in Gill versus Whitford, does a Justice Kennedy-like thing where sometimes Kennedy would say, well, this doesn't work, but kind of gives some suggestions. And that's what Kagan does in her concurring opinion, is sort of suggest ways that might meet judicial muster for intent and effect. But importantly, she says there's another part of the Constitution that could potentially come into play here, and that's the First Amendment. And so thinking about viewpoint discrimination, that ultimately what you have with partisan gerrymandering that makes it slightly different from racial gerrymandering and gives it a First Amendment impetus in addition to an Equal Protection Clause impetus, is that you have people who are singled out and disfavored, in terms of the impact of their vote on the basis of their political views. Yeah, so whether the court would go there, I don't know. But if you think about sort of where courts go generally, conservative justices tend to read the Equal Protection Clause pretty narrowly, but they tend to give a more expansive reading of the First Amendment to allow for broader freedom of speech. It's possible. Whether they would do it, I don't know. But this is sort of one approach. If you think about campaign finance and how basically almost all campaign finance restrictions have been decimated in the name of the First Amendment, this is possible. So Kagan has sort of said, and she's not the first person to point to the First Amendment, but I think it's interesting. So where the Gill versus Whitford goes, I'm not sure. But the Supreme Court isn't the only hope or the only place to look at for gerrymandering. And it's important to think about states as well. And so the Pennsylvania case wasn't escalated to the U.S. Supreme Court. It was decided on the statewide level based on a clause in the Pennsylvania state constitution. So in Pennsylvania's state constitution, they have a free and fair elections clause. And so what the state Supreme Court said was partisan gerrymandering violates the principles of their state constitution. And so they required districts to be redrawn. And so when this case was appealed to the U.S. Supreme Court, they said, hey, this is decided on state constitutional grounds. There's not a federal question here. We're not going to review this. And so this would be an option in 33 states. 33 states have free and fair elections clauses. Texas isn't one of them. No. But you know what? I mean, people don't read ballot propositions. So if you ever got like a ballot proposition in Texas, like it might go through because people, just have a tendency to check those. So I don't know. There are also, and here's where I think citizen movements come in. It is through legislative solutions, in particular, independent commissions. And independent commissions can take on several different forms, and I'll mention that. So in 34 states, the legislature is the sole determinant of how district lines are drawn. In 42 states, the legislature has the primary control, meaning in the other 8 states, they do consult with other bodies. So citizen groups, independent groups get to have some input, but ultimately the decision lies with the legislatures. 2 states, California and Arizona, use independent commissions for drawing all their districts, independent of the legislature. Some states use bipartisan commissions, and so those are, if you want to think like, if you're shooting for an independent commission to remove bias entirely and think about that as a gold standard, a bipartisan commission is going to bring politics in, but you'd be more like a compromise solution. So you could say it's probably the next best thing. The one thing about some of these independent commissions, though, is they vary with respect to how strictly independent they are. to put it delicately, to put it more bluntly, like some states don't restrict former legislative aides from working on the commission. So you can have, Joe Schmo legislative aide who just worked on a gerrymandered map 2 years ago, come in and now he's part of this independent commission. So Iowa's advisory commission is considered the gold standard because they have lots of checks in to keep lobbyists, and they have waiting periods between the time which you serve either in the legislature or as a legislative aide before you can be involved. And so this is an area that's in flux. There are 4 states that have ballot initiatives this year proposing independent commissions. It's Michigan, Utah, Colorado, and Missouri, not Texas. So where is Texas? So back in 2005, 2007, and 2011, Jeff Wentworth, who is a Republican from San Antonio, proposed a bill for independent commissions in the Texas state legislature, and it went nowhere. Which is interesting to me that someone even brought it up. So there's someone who's interested out there. So that's where we're at the state level. Thinking about the numbers. So this is the last point I have. So I like to look at 538. Sometimes it's like, you get down this rabbit hole of playing with 538 and you play with numbers and you never know where you're going. But they had a really nice tool that applies map making and demographics to consider sort of hypothetically what could Congress look like. And so they look at the current map and then think about what it would be. So currently you have at least they did this back in May, so it doesn't take into account any special elections that have happened since. 168 Dems, 72 Democratic controlled districts, 72 competitive districts, meaning ones where either party could conceivably win, and 195 districts that are considered predominantly Republican. You could gerrymander that to favor Republicans and get up to 275 safe Republican seats. So that's a difference of 80. In contrast, so in the current map, you have 168 safe Democratic seats. You could gerrymander that map to favor Democrats and get up to 263, almost 100 more. So our map it could be more gerrymandered in either direction. That's not a good thing. If you matched it to the current partisan break, you'd have 6 more Democratic sort of safe districts than you do now, and you'd have by their map about 16 fewer Republican safe districts than you have now. And so I think that's a good indication of how gerrymandered it is. And I was honestly a little surprised. I thought it was worse, and it could just be, some states are better at this than others. If, however, you used competitiveness, you wanted to draw lines as competitive as possible, and this wouldn't necessarily give you nice, compact, contiguous districts. So if you go look at their tool, you get a lot of little snake-like districts. It was interesting so I'm originally from West Virginia. We have 3 congressional districts, and so this one caught my eye because you would have a snake-like district that runs down the highway along with population centers from the 3 big cities, which are each about, max 50,000 people. Those are the cities. So it would take those in, and then all of the rural areas would be another one. And that's how you would get a competitive district, is to have this tiny little sliver that would basically be just a mile or 2 in either direction of the interstate that bisects the state. So competitive doesn't necessarily bring in other positive attributes. But with that one, you would get 242 competitive races, 94 safe Democrats, 99 safe Republicans. It's amazing, the difference. Yeah. It would make it sound, yeah. Now, they looked at it another way and said if you looked at sort of a way, one of the ways that, so the thing is, having a nonpartisan commission, that nonpartisan commission also needs to think about what their goals are. And so sometimes nonpartisan commissions, because they're going to be completely politically neutral, they're not going to take into account partisan breakdown at all. Often what they'll look at is existing communities of interest, county lines, city lines, et cetera. And so this map, you would have 155, with the map drawn this way, kind of how a nonpartisan commission would draw it. You'd have 155 Democratic seats, which is safe seats, which is about 13 fewer than you have now, 99 competitive seats, which is 17 more than there are now, and then 185 Republican sort of safe seats, which is 14 than there are now. So I think the takeaway from that is a nonpartisan commission, if they used sort of the compactness and the county lines and city lines and they redrew the map, it's not going to lead to significant changes, I think, in the way federal congressional maps are drawn. But that's just right, bingo. And so that it depends also, I think, where you see a bigger effect those at the local level. Yeah. But yeah. That's all I have.
Cool.
If you have questions, I'm happy to answer. I don't know if I know them, but if not, I'll write it down and come back. Yeah, great.
Real basic question. Who has the largest number of registered voters, Democrats or Republicans, in the state of Texas?
That's a good question. I don't know off the top of my head. I think,
Because you're,
yeah.
the way you were slicing it, it sounds like Republicans have safer seats. But I'd always heard there were more registered Democrats in Texas than there are Republicans.
So that is on the Texas Secretary of State's website. I can look that up in a GIF, but I don't know off the top of my head. I tend to look at turnout.
So, okay, so is the corollary to that is then with the gerrymandered maps, because it's all going to be gerrymandered, either by scientists or a bipartisan committee or by politicians. Yeah. Whatever, when you start playing with the map, if you said there were 10 Democrats in Texas and 11 Republicans, shouldn't the map somehow reflect the fact that Republicans are going to win 11 seats and Democrats 10 seats?
Yeah. And so there is one more divide. I forgot to mention this one. So if you match the party breakdown, then it gets more even. So then you'd have 174 Dems, 179 Republicans, just a marginal, and that's nationwide, obviously, and then 82 competitive. So it's pretty close. Yeah.
What about some kind of legislative fix that actually increases the amount of representation? So,
like blowing up the size of Congress?
Congress here and state.
So the congressmen.
Yeah, I mean, so I think that, so I see things like that where the argument would be that then you could have smaller districts that would then be, you would be more representative. But I don't know that that would erase the problem with drawing maps, because I think that would then give you 1,000 seats to then tinker with and draw and exclude people. But maybe you could say if you had more shots in the barrel, then you're more willing to let people have a voice.
Less bribery.
Yeah.
Our bias and stuff.
There are more seats you have to buy. So yeah, I mean, so it's interesting. And so the thing is, then you would think about, and this takes us in a different direction, is then what does a session of Congress look like? Does that then precipitate different challenges in terms of like, do you have even more gridlock because there are more people there? Does this increase the likelihood that a third party would have a chance if you have more seats? I think maybe not on the last question, because typically third parties, you need proportional representation for that. As long as you have first past the post, winner takes all, even if it's 1,000, you're still going to get a two party breakdown typically. Yeah, no, it's an interesting question. Maybe I could afford to run for Congress then, Yeah.
Another question. Does the Constitution guarantee one person one vote?
That comes from Reynolds versus Sims. So it's a Supreme Court interpretation of the Equal Protection Clause. One person per vote.
In that sense, I've never understood the fact that a state like West Virginia.
Yeah, right. We're overrepresented.
That's 2 senators and 3 representatives. In Texas, we have 2 senators.
Yeah.
That whole senatorial thing is the populations of some states have ballooned. We've never looked at the insanity of having North Dakota, which has the population of Dallas, is equally represented in the Senate as the state of Texas or California or Florida. And that to me is the unequal protection under the law.
Yeah, and so I mean, the idea would be that one clause in the Constitution can't conflict with another law of the Constitution. So because the Senate is its own institution, and the Equal Protection Clause doesn't change the composition of the Senate, it applies to how states treat people within their borders particularly. But yeah, I mean, that's a bigger structural problem that, I mean, and to be honest, small states are in no way going to give up that power. They weren't willing to give it up in 1777, they were going to give it up now. So yeah, or sorry, 1787. Then
But when the population's that disparate, even back in 1787.
Yeah, so so that's part of the whole, the argument in the founding, that under the Articles of Confederation, each state has one vote. You've got tiny Rhode Island, which is small, not just in land mass, but also in population. And you had far more densely populated Pennsylvania and Virginia that had the same representation. And so basically, this was a deal breaker for the small states, and there were enough of them that they said, we'll just walk away from this discussion altogether, and you'll get the status quo of equal state representation. And so then they come up with the great compromise we learn in civics class of, we'll have a Senate that maintains this equal representation from the Articles of Confederation, but then we'll bring in the new the House of Representatives, which then allows population to be taken into account. And then of course then you get another compromise entirely, the concession to the South and to slavery, where they said, well, yeah, and so because the southern states were less populous, so they said, well, now we want to be able to count our slaves as people in no other regard except for just when it helps us. So, yes, that's a structural defect that it would require a constitutional convention to remedy, and you've got Wyoming. I think, is Wyoming the least populous state?
Yeah.
Yeah. You have Wyoming, the Dakotas, West Virginia, Alaska, Rhode Island. None of these states are going to be like, yes, we'll give away our political power, sure. And that then has effects then, of course, for the Electoral College, which I think that is especially problematic. And so I think getting them to change the structure of the Senate who's going to give up power, right? No one. But a change to the Electoral College to popular vote probably still won't happen, because a constitutional amendment is so ridiculously hard to get through. But it's probably more feasible. Yeah, and I forget how many states are a part of that now. Yeah, but basically, we'll vote for the winner of the popular vote. Yeah.
You said that the lines are drawn on 3 different levels.
Mm-hmm.
So who draws each of those levels?
Yeah, so that's something that varies
Per state.
Yeah, so here it's the county commission that draws the county lines. Who draws do they do the cities too?
State legislature does the state lines.
Okay, yeah, state legislature does the state lines, but do cities do their own lines, or does the county do the city work on? Yeah, so that one I'm not sure about cities. That's something that that is controls. Yeah, but it's controlled by the state, and then the amount of control that local governments are given would probably be something that vary from state to state.
In some cities, you're like Hewitt, you're elected at large, and you have to be a certain size city to get that. You have to have a representational thing by district. And so I think I was wrong on that. I think the city does their own map drawing, because I remember a long time ago, a Baylor law professor had a commission to draw up the Waco map.
Yeah, and so I think there were 2 Baylor professors that participated in the most recent round and worked for the county on that. But so then they have to take into account, and then so cities would set their maps, but then in terms of how that would affect voting precincts and things like that would then go back to the county level. So it's a complicated process, and I don't make any claims to be an expert or to know a lot about that. And I still feel rather new to Texas, so I'm still learning a lot about how Texas works.
So the House is supposed to represent the population.
Yeah.
But when you have, I think it's millions more votes of Democrats, but yet the Republicans hold almost a supermajority.
Yeah. So part of that is I would say, and I don't want to write, so a little bit of it's gerrymandering, and a little bit of it is population distribution and where people choose to live. I think that it's that cities tend to be more liberal and rural areas tend to be more conservative and spread out. But I think that's also part of the problem as well.
So do we need a constitutional amendment to have more people in the House? Like more House district, can they just vote on within the House?
No, you would. So it's, that's a good question, because that the number isn't set in Article 1. 435, yeah, 435. It's a number, yeah. I have to think about that, but still, I think that it would multiply the problem that already exists. So you'd still have concentration of blue voters, typically in cities, concentration of red voters in rural areas, and purple voters in the suburbs.
If they portioned it to a specific amount of population, wouldn't that control the gerrymandering a little bit? Like, say, you're only allowed to do like no more than 50,000 people or whatever.
Yeah. Well, I mean, that's how it is now. So it's like one for every, I think it's like 200 and some thousand people. You get one. You get one. But the other problem is that that's also pegged to states. And so I think you can't erase state boundaries. So the state of Wyoming, with their member of Congress, has fewer people represented than some states. So that's allocated proportionally as well.
I guess you could draw start from the bare minimum and be like, that's the minimum. Whoever like Wyoming. So if every other state, you have to have, if Wyoming has one, that's one minimum.
Yeah, and so you could add more and then add from there. Yeah, that might be one way to do it, to make it more equal. And that would be interesting. You just increase incrementally the number of seats in Congress every year, and you're like, all right, so
every 10 years.
Yeah, every 10 years. Yeah, we're gonna add a few more seats to account for this. I see your point, and that makes more sense. Hey, let's propose a constitutional amendment.
Well, would that have to be in the Constitution at all then?
I think so, because of
the 200,000 thing is part of the Constitution?
No, so let's read it. I forget what it's called here. This is the remuneration. You would need to, in terms of, what you would need to change in the Constitution is the way that it's calculated. So what would need to change wouldn't necessarily be the number, but it'd be the pegged amount of, you base it on the smallest state. So that's the language that would need to change, as you would say, there's a threshold. The smallest state's population sort of serves as the base threshold for the one you need. The problem you get to then is like, what if a state qualifies for 2.5? Do you have like, a member of Congress that represents like, part of the, Eastern District of Western part of Louisiana and East Texas, and it's like,
give them 3 and let 2 outvote the other.
Yeah. So it gets tricky.
Whoever 2 degrees.
Yeah. No, it's a complex problem.
One more question. One of the things we're talking about, which sounds like the computer world that we're living in, that gerrymandering can be done down to house by house. Block
Scary.
by block, okay? Yet you said they're allowing the state legislatures to build districts with plus or minus 18 or 19% variance. And I'm going, why in the world would you have to have a crazy number like that?
Yeah.
If you can have computers make a district, make a gerrymandered district down to exactly the same number of people per district.
Yeah.
You should be able to do it. If you can gerrymander it,
you should be able to do that.
Create.
And so, so the answer I can answer for Texas, but I don't know for other states. So for Texas, part of that would come down to what's in Texas's state constitution, where in Texas's state constitution, it bases it on counties and county lines. So you get then another kind of political boundary that has state constitutional significance, in addition to state boundary lines having constitutional significance at the federal level, where it says counties have to be kept together, or counties
On the federal level.
This is at the state level, like counties.
Our county, Mary Ann Arnold and Catherine Turner Pearson are both running in the city of Waco.
Exactly. So, but each county needs to have at least one, I think is what is in the text. So even if there's a county that has a third of the population of McLennan County, they'll still get one. We get two because we have, or parts of two, you know. Does that make sense?
We have two that are both
Then rated,
deleted
yeah.
by all the other counties
Yeah.
that were guaranteed one.
Yeah.
And that's where the gerrymandering.
That's the problem, yeah. And so then you have provisions of the state constitution that then butt up against sort of compacting contiguous and drawing them equal. So that's part of the complication there. But yeah, I mean, I think it's perfectly fair if the state constitution notwithstanding, you should be able to get it down to, you know, within 5 people, I would think, to draw lines that way. I had some students who told me that she was a math major, and that there was a convention that she was going to in Austin where you could basically learn how to draw district lines. And so like training people to do this. And I thought,
I heard it on Science Friday, I think,
Yeah.
a couple of years ago.
Mhm. It's like draw maps and have a good time.
Alrighty,
Cool.
thank you so much.
Good.
Rebecca.
Were there any online people that might have questions? I don't know.
I checked and I didn't really see.
I was gonna,
If they
Yeah,
stayed here and
I-
listened to me the whole time, I want to make sure I answered their question too. Or maybe they turned off and they're like, this lady's crazy.
it exists eternally. You know, once you put stuff out there online.
That's true.
I don't see any major questions on it.
Cool.
But, thank you very much.
No, thanks for having me. It was fun. It was fun. I didn't know there too. I'm not crazy. I can't do it.
All right, well, thanks for joining us, guys. We hope to see you again soon.